Hello, I'm Jennifer Sigafoos, and I am giving you an introduction to my chapter in Debate and Charity Law. My chapter is Chapter 6, and it's entitled When Should Charities Be Allowed to Discriminate? The Case of Single-Sex Services and Transgender People. In the chapter, I explore the complicated interaction between equality law and charity law in England and Wales. What Morris has termed beneficiary discrimination is entrenched in charities, who often define their group of service users based upon specific protected characteristics under the Equality Act 2010, such as race, sex, or disability. This sort of discrimination in other contexts would not be allowable, but is allowable in some instances under a framework of exceptions and schedules to the Equality Act, such as the Section 193 Charities exception or the single-sex services exception. But in some instances, this discrimination is not allowable. So in my chapter, I use the case, if you will, of charities that offer women-only services and transgender women. Now, in many instances, this is not a point of conflict. A number of charities are able to accommodate all women, but in some instances, apparently, this is a point of conflict, and there seems to be considerable disagreement as to when transgender women are entitled to access these women-only services. So I consider the various legal bases for such a restriction on service users, and I argue that the circumstances in which charities may lawfully restrict their services to not allow transgender women to use them are in fact quite narrow, and this is especially true in circumstances when the transgender woman holds a gender recognition certificate. I conclude, therefore, that a blanket ban on transgender women is not lawful. A charity may exclude a particular transgender woman if it can be objectively justified. That is, that in this particular instance, this exclusion is a proportionate means of achieving a legitimate aim. I then turn in the chapter to considering what might help us to determine this proportionality under this calculation. I first look briefly at the concept of public benefit, a fundamental concept in charity law. Does it have some sort of what Parachin calls an aspirational element that says discrimination is incompatible with public benefits? Among others, the Charity Commission for England and Wales often conflates the Equality Act requirements and public benefit in a rather circular argument. If a would-be charity cannot satisfy Section 193 to justify its discrimination, then it is not acting in the public benefit. But if it is not acting in the public benefit, then it cannot register as a charity in the first place in order to avail itself of the Section 193 exception to allow this discrimination. So public benefit in and of itself does not then provide much help in deciding when this discrimination should be allowable, justifiable as proportionate. So in the chapter, I then turn to the bases of equality law to see if this can help. If we can situate this specialization on the part of charities within these theoretical underpinnings for equality law, then that might help to determine when these charitable purposes, when this charitable discrimination is objectively justifiable. So I look to a substantive equality framing to conclude that this discrimination by charities should only be justifiable in situations when a charity is challenging social structures that perpetuate inequality, and that therefore charity discrimination should only be able to be justified when it is operating as a tool for social transformation. Thank you very much. I hope you will enjoy reading this chapter.